Okay, hi Bhavan. I think most of us are back now. So let's get started. I think many folks can join as they arrive. So hi everyone, we are going to start with our doubt session for 15th May. And the plan for today's session is actually we received a lot of doubts, which makes sense because obviously the exam is much closer now. So we got many more doubts than we normally get. So they're all in this presentation, but I don't know if we will have time to go through all of them today. We're going to try, but what we've done is we have prioritized them. There are a few logical reasoning doubts and there are lots of legal aptitude doubts. And as you all know, legal aptitude is the most important, one of the most important sections for DU. Logical, not so much. So we'll spend time accordingly. There are a couple of small and interesting logical problems that I'll just do right now. And then I'll hand over to Madan sir. There are lots of interesting legal questions that we should get, which I think will be of benefit to everybody. And then if we have time, if time permits, then we'll go back to some more logical questions. But that if it doesn't happen today, then I'll make sure to upload a video solution of it in the next few days. But like I said, we have prioritized them in decreasing order of importance. So with that, let's get started. This is the first question that we have. It's a logical reasoning question. And it's actually from the material. One of our students asked it as a doubt, but it is from the material. And the question says, 4 members have to be nominated to a committee and there are 6 candidates, A, B, C, D, E and F. And there are some restrictions that are given. If A is nominated, then D does not find any place. If B is nominated, and so on and so on. And we are being asked which of the following is an acceptable combination. So this question does not require any writing. You should not have to put your pen on paper at all. You should be able to do this mentally. So let's take 20 seconds and if you can just write the answers in the chat window. Yes, Samir, Hema, both of you are right. Yeah, Bhavan, you're also right. The answer is C. That's right. The right answer is C. This should be a fairly simple question. The way to solve it is basically you look at applying each of the conditions. There are 3 conditions given, A, B and C. You have to apply these 3 conditions on each of these choices. That's it. Nothing much more to do. So if you look at choice A, you have A, B, C and D given here. Now, the first condition is saying if A is nominated, then D should not be there. That is fine. Then you have if B is nominated, then either E or F, but not both. That is also fine. Then you look at C. If C is nominated, then both D and E have to be nominated. This one has failed, right? Because you have A, B, C and E. So C was nominated, but D is not there. Only E is there. So that way you cancel out choice A. And similarly, you'll be able to cancel out choice B and choice D, and you'll be left with choice C only, which is the right answer. So that's good. Let's move to the next question. Now this question is a direction problems question, and it's quite interesting because there are no directions given to you. All you're told is left and right. So let's take 30 seconds, go through the question, and then you can tell me the answer in the chat window. Okay, Mr. Sopti, any other answers? So 2 people feel that the answer is A, X Street. Any other answers? You should be drawing the diagram, guys. This is not a question to solve without drawing the diagram. If you draw the diagram, it will be very straightforward. He's on the cut on X street and Y street, like the corner, Bhavan? You mean where X and Y intersect? Okay, that's interesting. But sorry, that's also not the answer. So let's see how to solve this question. I've got the diagram made now. I have reduced the size of the question and I've just made the diagram here. So this is what is happening. You see the 1, 2, 3, 4, 5, 6. Yeah, so the answer is Y. You're right, Vikram, the answer is Y. So see what's happening here, right? Let's say this was the starting point, okay, 1. This is the starting point, and we are told, the first sentence says, he walks 10 yards down X street. First point of confusion which may occur for some students, what does this word down mean, right? Now down is not south, it's not north, it's just that you're walking along. It's a way of speaking in English, it's just saying that you're walking along a street. In this question, there is no sense of direction. You are not told north, west, east or south. You're just told certain streets. So X may be, I have drawn X from west to east, but you could draw X from south to north, northwest to southeast, doesn't matter. In this question, all the directions are relative. So I've arbitrarily chosen X to go from left to right, but there's no sense for this, there's no logic for this. You can choose X to be in some other direction also, that's fine. Now you're told he walks 10 yards down X street, that is this 1 to 2, that is the 10 yards along X street. Then he turns left. A left turn is in this direction. So he turns left and walks 10 yards down Y street. So 2 to 3, those are the 10 yards down Y street. Again, down doesn't have any meaning, right? It's just a way of speaking, it's a figure of speech. So now you've reached point 3. He again turns to the left and walks 10 yards down Z street. So one more left turn, another 10 yards, and he has reached point 4. This street was called Z street. And now the question runs out of street names. Now the streets don't have any names at all. At point 4, he turns to the left. We are here, right? At point 4, he turns to the left and walks 15 yards down another street. So point 4, left turn, 15 yards to reach point 5. Okay, now we have reached point 5. And then he turned to the left and walked 10 yards down that street. That street is a different street. We are not told the name. We are just told that he turned left and walked 10 yards. So he is now from 5, he is moving to 6, and this distance is 10 yards. Again he turned to the left and walked 5 yards. Which street was he on? So now at 6 he turned left and walked 5 yards. So now you can see the diagram is making sense, right? He's reached back to point 2 again. So Bhavan, your answer is, strictly speaking, I could argue for it. It's on the cut between X and Y street, is not completely wrong. But since you had to choose one of these options, A, B, C or D, so you would have to choose that he is now entering Y street because he is in that direction, right? X street is going in this other direction, 90 degrees or perpendicular. So Y street is where he is entering. If there was an option, if let's say D option, instead of saying none of the above, if it was saying intersection of X street and Y street, then certainly that should have been the right answer. But since that is not given, so you have to choose that he is about to enter Y street. So the answer would be B, Y street. If we say D, yes, it would be wrong because you have a better answer. You're trying to find the best answer here. And in general, if you're entering a street in a certain direction, even if you're just at the mouth of that street, it would still be that you are in that street. So if you're standing at point 2 but you're facing towards point 3, then the answer would be that you are on Y street. Yeah, Mr. Sopti, I think that was a mistake, so we've corrected that. Possible, yeah, that's possible. So we've corrected that. This question is actually from the test only. I think you had only asked it. So that's why I thought it's a good question, and since other folks also might have got confused, so we decided to solve it here. Any other doubts? Any other questions in this diagram or in this question itself? Okay, great. So now we'll move to some legal aptitude questions. Like I said, there were a couple of logical reasoning questions that I wanted to deal in the beginning. Now we have plenty of doubts in legal aptitude and they're all quite interesting. So I'll now hand over to Madan sir. He'll take us through these questions, and of course the video recording will be updated later, but You have Sir available to you live right now. So if you have any doubts, do feel free to use the chat window.
Dear students, let's move on to the legal aptitude portion. Uh, First principle is here before you. A person shall not be guilty of contempt of court, shall not be guilty of contempt of court. So this is how we are starting. A person shall not be guilty of contempt of court on the ground that he has published any matter which interferes with or obstructs or tends to obstruct the course of justice in connection with any civil or criminal proceeding pending at the time of the publication. So normally if there is obstruction of or interference with justice, then it is contempt of court, but this is the exception. It says that it shall not be treated as contempt of court, and then we come to the condition that if at that time he had no reasonable grounds for believing that the proceeding was pending. So this is the important line. It says that a person shall not be guilty if at that time he had no reasonable grounds. At that time means at the time of the publication. If at that time he had no reasonable grounds for believing that the proceeding was pending. So this is the principle. Now we move on to the factual situation. It says X delivered a lecture at local Rotary Club in favor of an accused who is prosecuted for assaulting a police officer. He said that the accused is a victim of prevailing corruption in the judiciary. He means X. So X in his lecture says that the accused, and who is accused? Accused is the person who is being tried for assaulting a police officer. So X in his lecture says that the accused is a victim of prevailing corruption in the judiciary, and he knows, so he has the knowledge that the accused is going to be punished by the court for being honest. Is X guilty of contempt of court? So I'll give you a minute. Just again go through the legal principle, go through the factual situation, and then let's arrive at a correct decision. Okay, so let's now move on. First, there is a question from Bhavan. He wants to know what does publication here refer to? And that's a good question because there is no publication as such in the way we understand it. But a speech is also a publication for our purpose as far as this principle is concerned. So when he is delivering a lecture, he is publishing his thoughts, and that is to be treated as a publication. So that's what it means for this question. Now, any other question? All right. Coming to the answer, uh, the correct answer is B. X is guilty of contempt of court, and the principle is very simple. There is an exception only if, as we saw earlier in the principle, only if at that time, that is at the time of the publication, he had no reasonable grounds for believing that the proceeding was pending. But here definitely he is aware that a proceeding is pending. In fact, he is accusing the judiciary straight away, saying that there is corruption in the judiciary and that's why he is going to be punished. So he is very much aware that the proceedings are pending, and despite being aware of that fact, he makes the publication, that is, he makes the speech, he makes his thoughts known, and therefore we can very clearly arrive at the decision that X is guilty of contempt of court. Any questions on this? Yes, there is a question which says that, there is a thought from Naman which says that he is not done anything which interferes the course of justice. Yes, he is accusing the judiciary directly. He is saying that there will be no justice in this case. He is saying that there is corruption in the judiciary, and he is saying that the accused will be punished not because he is guilty, but because there is corruption in the judiciary. So this amounts to in a sense, it amounts to interference in the working of the judiciary, and that is how the courts have been interpreting it for so long. Therefore, we would say that this is a clear case of contempt of court. Shall we move on? Okay. The next legal principle is before you. No person shall be convicted of any offence except for violation of a law in force at the time of commission of the act charged as an offence. This is the first part of this principle. There is a second part also, which says that no person shall be convicted, nor we can say no person shall be convicted, or no person shall be subjected to a penalty greater than which might have been inflicted under the law in force at the time of commission of the offence. Now this legal principle, if you can recall, is clearly incorporated in the Constitution of India in Article 20, and it clearly spells that the thing which is to be treated as an offence should have been so, or should have been an offence at the time when that act is committed, which means that no offence can be created ex post facto. Something or some act which was not an offence at the time of doing that act cannot be made an offence subsequently. You can distinguish this principle from the normal law-making principle, which, for example, taxation. A tax can be levied retrospectively also, but an offence cannot be made retrospectively. So this is what it incorporates. And secondly, it talks about the penalty also. It says that no person can be subjected to a greater penalty than what was provided in law at the time when the act was committed. So neither the penalty can be greater, which means it can be smaller. So penalty cannot be greater than what it was at the time when the act was committed. And of course, if an act was not an offence at the time of committing it, then subsequently by law it cannot be made an offence. This is what the legal principle is. And moving on to the factual situation. A boy of 16 years was convicted of house trespass and theft. He was sentenced to imprisonment for 6 months and fine was also imposed. After the judgment, the Probation of Offenders Act came into force. It provided that a person below 21 years may not ordinarily be sentenced to imprisonment. Now the boy claims the benefit of this act. Should he get it? I'll give you half a minute. Just go through the principle and the fact, and we'll arrive at the decision subsequently. All right. Uh, let's see now. I'm getting various answers, but mainly B and C, B and A. All right. Even while I was telling you the principle, I had said one thing which, if you had noticed, you would get the answer from there itself. Uh, in this factual matrix, the second part of the legal principle is applicable, which says that no person shall be subjected to a penalty greater than which might have been inflicted under the law in force at the time of commission of the offence. So there is a blanket ban by the Constitution or by this legal principle against infliction of a penalty which is greater than what was prevalent or what could have been levied at the time when the act was committed. But it does not say anything about a penalty being lesser subsequently or being reduced subsequently. Now in our factual situation, there was a provision for imprisonment earlier, but subsequently a law was made, Probation of Offenders Act, and it says that a person below 21 years may not ordinarily be sentenced to imprisonment. The boy is, or rather was, 16 years of age at the time when the offence was committed, and the Probation of Offenders Act gives him the benefit that ordinarily he should not be sentenced to imprisonment. But this act came onto the statute book subsequently. Now the question is whether a subsequent act can reduce the penalty. So obviously yes, there is no bar. The bar is only for the penalty to have been increased. In this case, penalty is sought to be reduced, and the principle does not bar reduction of a penalty subsequently. Therefore, the correct answer is A, which says that the rule of beneficial interpretation required that the benefit of ex post facto law can be applied to reduce the sentence. Ex post facto law means a law which has been made subsequent to the act which has been which is the offence. So by subsequent law the penalty is reduced, and this benefit can certainly be given to the offender. The principle merely says that penalty cannot be greater. It does not say anything about penalty not being lesser, and in this case the penalty being lesser, the benefit should be given to the boy. So the correct answer in this case is A. Okay, any questions? All right, moving on to the next. The principle here is, if a person transfers movable or immovable property with its full ownership and without any consideration to some other person, then it is called a gift. So, what is a gift? Gift is firstly transfer of movable property, transfer of immovable property. Now, transfer is of various kinds, but for a gift, the transfer should be complete or absolute, which means that full ownership rights should be given. So, in a case where full ownership rights are given, and next condition is that there should be no consideration. So, there should be a transfer. The transfer should be of full ownership rights, not merely of right of possession or right to enjoy, etc. And the third condition is that there should be no consideration. So, alright, so this is what is gift. Now, moving on to the facts. S, who has no child of his own, makes a gift of his house worth rupees 25 lakhs to his nephew R. So first of all, let us see from here that the gift is of a house property and the property is worth 25 lakhs. Now yes, there is no bar of making a gift to the nephew, so far so fine. After completing all the legal formalities required for a valid gift, S says to R that in case of need, R would need to provide the house to S for use without any questions. So here S is simply wanting the use of house for himself in a case where he needs it. Then after 1 year of this gift, S is in requirement of the house and requests R to make the house available to him. But R refuses to do so. Now since it's a gift given by S to R without consideration and all these things, now can R refuse S the request which he is making? Just give it a thought. I'll revert to you in half a minute. Alright, we are getting various answers, A, C, etc. But most of you are saying it should be A. I think it's a straightforward question. Firstly, it is a gift. The very first line says that S, who has no child of his own, makes a gift of his house. So we know from the very first sentence of the factual matrix that it is a gift. And then let us move on to the principle which says that a gift is something which a person transfers with full ownership rights. Here the property has been gifted to R, which means the property has been transferred to him with its full ownership rights, and full ownership rights means right to possess, and right to alienate also, right to transfer it subsequently, etc., right to enjoy. So since it is a gift and all gifts are without consideration, so one of you is saying that since it is without consideration, I should be allowed to occupy it. All gifts are without consideration, and since full rights are now full rights have been transferred to R is within his rights not to allow S any occupancy of this house. Whether he needs it or doesn't need it, that is immaterial. The very concept of gift gives absolute rights to the donee, the person who has received the gifts, and thereafter it is absolutely his discretion as to how he uses that house, how he enjoys that house. So the answer is A. R can refuse as he has become full owner of the house. Uh, Bhavan is saying that without consideration there is no contract and so it ab initio. Yes, it's not a contract, and that's why a gift is a special type of transfer where you don't need a consideration, and obviously if there is a consideration it will be a contract, and then it will all depend upon what were the terms of the contract, whether the contract provided that as should be allowed to occupy it as and when he needs it, etc. So no question of that. And full ownership rights have been transferred. Therefore, it is for R to decide as to how to use that house. Okay. Moving on to the next question. The principle here is generally an agreement without consideration is not valid. Yes, that's what we were saying in the earlier part also. Generally, an agreement without consideration is not valid. I will not say it in. I mean, this is the principle which has been given to us, but in law, we do not say that the agreement is not valid. Agreement is valid, but it cannot be enforced by law, and therefore it is not a contract. That's what we can say. Anyway, as far as this principle it says that generally an agreement without consideration is not valid. Alright. Therefore, in order to make a valid agreement, some consideration which may have some value in the eyes of law is essentially required. So there must be a consideration for the agreement to be valid, and that consideration should have some value in the eyes of law. Moral considerations or emotional considerations, such considerations are not relevant. So such types of considerations have to be distinguished. Now, facts. William has an old car which he seldom uses. He voluntarily enters into an agreement with Smith to sell this car for rupees 10,000. So there is an agreement to sell the car. Consideration is 10,000. Thereafter, one Anson approaches William and offers to buy that car for rupees 1 lakh, as the car was one which Anson had been searching for long. So he is now making an offer, Anson, of a higher consideration. Now William wants to cancel his agreement with Smith and refuses to deliver the car to him, saying that consideration or the price for the car promised by Smith is negligible, and therefore agreement with him cannot be said to be a valid one. So now, since the instead of using the word negligible, we can also say that the consideration which was offered by Smith was inadequate. It seems that the car is worth rupees 1 lakh, but the earlier agreement is only for 10,000. So the consideration which was offered by Smith was inadequate, and on this ground, William is now trying to hold that the agreement is not valid because there is inadequate consideration. So let's see. Just give it a thought for half a minute, then we'll come to the answers. All right. I think the question is quite straightforward. Most of you are able to answer it. The correct answer is A. William cannot cancel his agreement with Smith as the sale of car for rupees 10,000 was voluntary and this price has some value in the eyes of law. Definitely 10,000 has a value in the eyes of law. And as I said, the principle says that there should be some consideration. Mark the word some consideration. It does not say adequate consideration. So for an agreement to be a valid agreement, there should be some consideration which may be adequate, which may not be adequate. To some it may be, to some persons the consideration may sound adequate, to others it may not sound adequate. But that is not the point. There should be some consideration which may have some value in the eyes of law. So monetary consideration definitely has a value in the eyes of law. And it is immaterial whether the consideration is adequate or inadequate. The principle also does not say that the consideration should be adequate. Agreed, this in this factual matrix, the consideration is not adequate. 10,000 as compared to 1 lakh is certainly inadequate. But that is not the point. And therefore, the correct answer is A. Okay. And in option A, the second part is to be cancelled out. Only the first part is relevant, where the second part is in fact coming from option B. Same thing. So that you can ignore. Alright, moving on to the next question. The principle here is, if a contract is made by post between two persons living in two different cities, then the contract is said to be complete as soon as the letter of acceptance is properly posted and the place of completion of the contract is that city where acceptance is posted. Now here there are two principles in this one particular sentence. Firstly, it says that the contract is complete at what point of time? As soon as the letter of acceptance is posted. So this is the time at which the contract is said to have been completed. And secondly, the place of the contract. It says the place of the contract is that city where acceptance is posted. So just note carefully these two aspects. Completion of the contract as soon as the letter is posted, and the place of completion is the place where the letter is posted. Okay, then it says it's worth mentioning here that in every contract there is always an offer from one party and the acceptance of the offer from the other party. Of course, we all know it that every contract must have two components. Firstly, there should be an offer by one party. Secondly, there should be acceptance of the offer from the other party. So that is adding not much to what we are required to do. Alright, now facts. Sunny, a resident of Patna, gives an offer by post to sell his house for rupees 25 lakhs to Honey. The offer is made from Patna by Sunny. And this Honey, the person to whom the offer is made, is living in Allahabad. Now this offer letter is posted on 1st January 2013 from Patna and reaches Allahabad on 7th January 2013. It has reached Allahabad on 7th. Now Honey accepts this offer and posts the letter of acceptance on 8th January 2013 from Allahabad. Now again note here carefully that the acceptance is posted on 8th January and from where? From Allahabad. And as far as the principle shows, these two aspects are important as to when the letter is posted and from where it is posted. Subsequently, we are given that the letter reaches Patna on 16 January 2013. So, the offerer or the person who makes the offer, that is Sunny, who is living in Patna, actually receives the letter only on 16th. But Sunny, presuming that Honey is not interested in accepting his offer, sells his house to Gani at the same price on 15th of January, that is before the letter reaches him. The owner of the house, thinking that Honey is not interested in the house, in fact sells it to some other person. The price is the same and he sells it on a day previous to the one on which he receives the letter of acceptance from Allahabad. Hani files a suit against Hani for the breach of contract in the competent court of Allahabad, whether Hani will succeed. So it's an interesting question. I'll give you a minute. Go through the facts and the principle, and then we'll discuss as to what should be the correct answer. Okay. Yes, there are certain questions from the participants. Lopreet is saying, I believe that there might be a time limit, but since it's not mentioned anywhere in the principle, we must not consider. Some people are asking what should be the time limit for acceptance, or for that matter, how long should the person who is making the offer wait for the acceptance. Now, in this particular case, of course, the offer was made on 1st January, it reached Allahabad only on 7th, and on the very next day the offer is accepted, and then within a week it reaches Patna. So there is not much time gap as such. The offer was made on the 1st and the acceptance is received back in Patna on 16th. So here the time gap is not much, but I would say as a matter of principle that even if there is a greater time gap, even if the person to whom the offer is made takes his sweet time and does not reply for a long time, what matters is whether he has accepted and posted the letter. See, if the offerer, if the person who is making the offer is particular about timing, then in his offer letter he can mention that the reply should be given by within a week or within 10 days or by such and such date. That is one way of curtailing the time gap if he is apprehending such a thing. In case the offer is open-ended, in case the offer does not give any time limit for its acceptance, then the offerer has no choice but to wait for a reasonable time, of course. And what is reasonable time? That again is subjective and it will depend upon the discretion of the court as and when the matter goes to the court. But for the time being, and as far as this question is concerned, since in the offer there is no time limit, therefore the 7 or 8 days which have been taken by in the process of acceptance has to be acceptable to the offerer. Secondly, what matters is the date of putting that letter into the letter box. Once the letter has been posted, then the acceptance is complete as per the principle. And thereafter it does not matter as to how long that letter takes to reach the person who made the offer initially. So well, you can say that in our Indian system, a letter may reach the offerer even after a year or so. But even then, once it has been posted, then the transaction is complete as far as both the parties are concerned. And it becomes binding on both. The principle says so. And therefore, it's very clear that once the letter was posted on 8th January, the transaction was complete, acceptance was complete, it became binding on both the parties. Thereafter, it doesn't matter how long that letter takes in reaching Sunny, in reaching Patna. In this case, it reached in just about 8 days, but it might have taken longer. Even then, the answer would remain the same. So, with this understanding of the law and the facts, now we can say that the correct answer will be D. Honey can succeed as contract became complete in the eyes of law on the date of posting the letter of acceptance. Okay. And there is a question whether this is the situation as per the real contract act. Yes, it is the same. The real contract act also says the same thing, that once the letter has been put in the post box, once the acceptance, in fact the act says that once the acceptance is put into a course of transmission so as to be out of the control of the acceptor. This is the language which is used in the contract act. So it may be a letter, it may be mail or whatever. Once the acceptance is put into a course of transmission to the offerer so as not to be within the control of the acceptor, in that case the acceptance is treated as complete. So any other question? Alright, moving on to the next one. The principle here is, a person is said to be of sound mind for the purpose of making a contract if at the time when he makes it, he is capable of understanding it and of forming a rational judgment as to its effect upon his interests. So, who is treated as a person of sound mind? This is what the principle says. Why it is needed? Because the contract it says only a person having sound mind is capable of entering into a contract. So therefore, we need to know as to who is to be treated as of sound mind, and this principle says that for a person to be treated to be of sound mind, he should be capable of understanding the contract. That is the first requirement. He should be capable of understanding the contract. Secondly, he should be capable of forming a rational judgment as to the effect of the contract upon his interests. If these two conditions are satisfied, and when these two conditions are to be satisfied at the time when the contract is made, so the time is very crucial. If at that time he is capable of understanding the terms of the contract and is also capable of making a rational judgment as to its effect upon his interest, then he is to be treated as of sound mind, and such a contract will be a valid contract. X, X, who is usually of sound mind but occasionally of unsound mind, enters into a contract with Y when X is of unsound mind. So the contract is made when X is of unsound mind. Y came to know about this fact afterwards and now wants to file a suit against X. So I think it's fairly simple, but still I'll give you half a minute to go through the facts and principles once again, and then we'll discuss the answer. let's move on. Now, the first choice says X cannot enter into the contract because he is of unsound mind. Fairly simple. X cannot enter into the contract because he is of unsound mind when he entered into the contract. Now, to some, B and C also seem to be of importance or relevance. B says X can enter into the contract, but the burden is on the other party to prove that he was of unsound mind. And C says X can enter into the contract, but the burden is on X to prove that he was of sound mind. So both options B and C are speaking about the burden of proof as to who is to prove the fact of soundness or unsoundness. But in my view, as far as the principle is concerned and as far as the facts are concerned, the question is not regarding as to upon whom the burden of proof is. As a general principle of law, burden of proof is always upon that party which goes to the court and claims something. So if Y goes to the court and saying that X was of sound mind, the burden to prove that X was of sound mind lies on Y. If X goes to the court and says that I was of unsound mind, the burden is on X to prove that he was of unsound mind. So that is the principle regarding as to upon which party the burden of proof will be there. But as far as this principle is concerned, it does not concern itself with the burden of proof. It is simply saying that any contract which is made by a person who is of unsound mind is not a valid contract. So clearly the answer is A. X cannot enter into the contract because he is of unsound mind. And this is a matter of fact because in fact the facts also say in the last part that Y came to know about this fact. So this is a fact that X was of unsound mind at the time when the contract was made. Therefore, let's not go into B and C as to upon whom the burden of proof will be there. We are concerned whether the contract is valid, whether X was capable of making the contract, and it is almost it is an established fact that he was of unsound mind at the time when the contract was made. Therefore, the correct answer is A. Okay. Any questions on this? All right. Moving on. I think that's all. We have finished all the questions. So now I'll hand over the stage to Vivek sir. Oh, there is one more question. Yes. All right. In this case, there are two principles, principle 1 and principle 2. Firstly, it says a principal shall be liable for all the acts of his agent done in the course of employment. Please don't get confused. First is principal, second is also principal. So here the principal in the second part is principal and agent concept. So a principal shall be liable for all the acts of his agent done in the course of employment. That's what the first part is. And second part says A shall be considered an agent of B. It says, or rather it tells us as to who is to be treated as an agent. A person shall be considered an agent provided that B remunerates A and B has direction and control over what A is doing. So essentially in the second part they are telling us as to who is to be treated as an agent. For an agent, two requisites are there. Firstly, there should be remuneration, and secondly, there should be direction and control over what he is doing by the principal. With these two principles in mind, let's move on to the facts. The Consolidated Motors was a firm dealing with the second-hand cars. Suresh came to the office of the firm and offered to sell their cars, provided he would get an 8% commission on cars sold by him. The Consolidated Motors agreed to the proposition. One day, Suresh took out a car for the purpose of demonstration to a prospective client, and in the course of demonstration, which means in the course of employment, he knocked down Ramesh and injured him. Ramesh is seeking legal remedy. The main issue is whether Suresh is an agent of Consolidated Motors. So the first part is not relevant here. In the first part of the principle, we says that a principal shall be liable for all the acts of his agent done in the course of his employment. We are concerned with the second part as to whether on the given facts Suresh can be treated as an agent of the consolidated motors or not. So let's consider it for half a minute. Alright, now let's see whether Suresh is an agent of consolidated motors or not. Let's see the first choice. He says that Suresh is the agent of consolidated motors because he gets remuneration by way of commission. So getting remuneration is only one of the conditions, and therefore we cannot give a positive answer just from this one simple fact that he is getting remuneration. So I am doubtful about A. Moving on to the B, choice B. Suresh is not the agent of consolidated motors because commission is not the same as remuneration. Well, here we can say that remuneration can be in any form. Remuneration can be in the form of commission, remuneration can be a part of, let's say, percentage of profits, remuneration can be fixed, remuneration can be variable, etc. So, we are not going into this particular aspect. As far as this question is concerned, we need not answer this definitively. In my view, answer C is the correct answer, which says that Suresh is not the agent of consolidated motors because the latter does not have control over his activities. Suresh is offering his services on the simple proposition that the number of cars he sells, he'll get a commission of 8% on those cars. That's all. Now, how he is going to sell them, that is solely and exclusively upon him. The method of selling, how he convinces, that there are no guidelines, there is no control from consolidated motors as to how he should conduct himself. Therefore, A and B being doubtful, I think C should be marked as the correct answer. And it is better to answer in negative because for the positive answer we need both the conditions. So as far as A is concerned, simply because he gets remuneration, obviously this cannot be correct because for an agent two conditions must be satisfied, then the answer must speak of both the conditions. So A is definitely not the answer, and C should be correct. So any payment, yes, any payment is remuneration. And Pradeep is saying that this question has different answers in different books, and so Samir is saying in the law chapter. Anyway, if there are different answers in different books, uh, let's understand the logic. As I said, A is not correct because for an agent, two conditions must be satisfied, and option A is speaking only of one condition. Therefore, there cannot be a definitive answer from A. And as far as B is concerned, there is we can always say that commission is just a form of remuneration. Therefore, B is also not correct, and therefore, by the process of elimination, also C seems to be the correct answer. Okay, moving on. Uh, there is one response which says that in most of the books B is the correct answer. I would say that choosing between B and C, there can be a difference of opinion whether commission can be treated as remuneration or not. But definitely in this case, as the facts show, there is absolutely no control by the consolidated motors firm on the activities of Suresh, and therefore to me C seems to be a better option as compared to B. Alright, moving on to the next. Principle is, even if the sovereign functions of the state are discharged negligently, the state is not vicariously liable in tort. Well, there is a principle of tort which says that the state is vicariously liable in general, but not in respect of sovereign functions of the state. So now the functions of the state are divided in two parts, sovereign functions and non-sovereign functions. Non-sovereign functions can also be termed as welfare functions or social functions like that. Sovereign functions are those functions of the state which are essential and which are performed exclusively by the state. Now let's see the facts. A was a gold trader. He was arrested by police and detained in the police lockup after search. The gold with him along with sundry other things was seized. Later he was discharged. His possessions seized by the police were returned except for the gold. He moved against the state in tort. In the words of the Supreme Court, there can be no escape from the conclusion that the police officers were negligent in dealing with the property after it was seized. One of the constables was a Muslim. He fled with gold to Pakistan. Well, it's fairly straightforward. Still, I'll give you half a minute to ponder over. Well, most of you are saying it's C, and the correct answer is also C. A will fail because the acts of search and seizure by the police officer were part of the sovereign functions of the state. It's fairly simple. Acts of arrest, acts of search and seizure, etc. These are sovereign functions, and it's only the state who has the exclusive power to do these things. And what the act of negligence or act of malfeasance, whatever it is, that was done by a servant of the state, but he committed the act while performing the sovereign functions of the state, and therefore the state is not vicariously liable in tort as the principle says. So fairly simple, the answer is C. I don't know how some books are giving a different answer. Anyway, moving on to the next. Again, the principle says that the state is liable for the acts of its employees when the act is of private nature, in the same manner under the same condition as any other employer. So private nature here means anything which is non-sovereign. The state is not liable when the act is in the exercise of sovereign power or in performance of an act of state. So the principle is the same as we saw in the last question, that the state is vicariously liable for any act which is non-sovereign. The state is not liable when the act is of or the function is of a sovereign nature. Now on the facts of the case, we see that an army truck was driven by a military driver A and was proceeding on duty to carry the army men on duty at different military posts. The truck was ferrying army men to different posts and it was being driven by a military driver. The truck hit a civilian B and caused material injury. The facts show that the injury was caused due to the rash and negligent driving of A. The injured civilian brought a suit in tort against the Union of India. So what we have to see whether the function is sovereign function or non-sovereign. The answer will depend on that. So I think we need not spend much time on this. As we saw in the last question, there the act was arrest and search and seizure, which was a sovereign function. Here the act is driving the army men to different duty posts. Definitely it is a sovereign function, and whatever happens in the sovereign function, the state is not liable very clearly, and therefore the correct answer is D. The person will fail in his suit because the incident occurred in the discharge of the sovereign functions of the state. Narayan is asking whether I can explain what is sovereign and what is non-sovereign. Well, as I said, sovereign functions are essential functions of the state which nobody but state can undertake. For example, military or rather the defense functions, and then dispensing of justice, law and order. I can say these three are the major sovereign functions: maintenance of law and order, dispensation of justice, and defense. And anything incidental to these functions will also be treated as a sovereign function. Anything relating to welfare measures of the state, like education, like road making, like power supply, all these functions, telecommunication, postal department, these are not essential functions, because if the postal department is not functioning, there are private couriers who will take our post to different places. Education is being provided by private players also. Similarly, roads can be made by private people also. So these are not sovereign functions. Sovereign functions are those functions which only state can undertake and no one else. Alright. Then the next principle. A contract is a private relationship between the parties who make it. The rights and obligations under a contract are confined to the parties. When a party commits a breach of contract, it shall compensate the other party for the loss. So the principle says that whenever there is a breach of the contract, then the party who commits the breach will compensate the other party. And the word used is compensation, as you might have noticed. Now let's go through the facts. Messrs. Pine Electronics, a firm of wholesalers, bought 100 Videocon TV sets from the manufacturers and sold them to Messrs. Durchitra Enterprises, a firm of retailers. So they are wholesalers and they have purchased them and sold them to the retailers. Now Durchitra Enterprises agreed with Mrs. Fine Electronics, that is the wholesalers, that they will sell the TV sets at Videocon's list price in conformity with Videocon's policy. So this contract is between the wholesaler and the retailer, that the retailer will sell it in conformity with the price list issued by Videocon. They also agreed with the wholesalers that they would pay rupees 4,000 as compensation to Videocon company on every TV set sold below that list price. So these are the terms of the agreement. Later, because of intense competition in the market, Durchitra Enterprises sold some TV sets at less than list price. Thereupon, Videocon filed a suit against Durchitra Enterprises and claimed compensation. Durchitra Enterprises claims that they are not liable to pay compensation. Who will succeed? Now, this is a good question, because here the claim is made by Videocon, which was not a party to the contract. So we have to consider whether they will be able to succeed in the suit. I'll give you a minute to once again go through the facts and then we'll discuss. Okay, now let's start going through the facts again. Firstly, let's understand that there was a contract between the wholesaler and the retailer. And the principle says that a contract is a private relationship only between whom? Between the parties who make it. So which are the parties here? The parties are the wholesalers and the retailers. Videocon is not a party to the contract. And the principle says that the rights and obligations under a contract are confined to the parties. So this is very important. The rights and obligations under a contract are confined to the parties. When a party commits a breach of contract, it shall compensate the other party for the loss. So very clearly, the rights and obligations are between the parties. Videocon is not a party in this case, and despite that, Videocon has gone to the court. Videocon has filed a suit. Videocon has no locus standi to file a suit because it's not a party to the contract. Though straight away we can rule out that Videocon will not get any relief from the court from a contract to which it's not a party. So apparently answer should be B. Durchitra Enterprises is not liable to compensate Videocon for the reason that Videocon is not privy to the contract between Pine Electronics and Durchitra Enterprises. Is it clear? But still, some of you might say that In any case, there was a contract between the wholesaler and the retailer, and the contract itself provided that the wholesaler that rupees 4,000 will be paid as compensation to Videocon company on every TV set sold below the list price. So one might argue that the contract itself provides that 4,000 will be paid to the Videocon company, and in this case Videocon company is claiming. So apparently, as per the contract itself, Videocon becomes entitled to this compensation. Well, we can resolve this dichotomy in this way. We can say that Videocon company by itself does not have a locus standi or does not have a right to go to the court. It should have been the wholesalers, should have been in electronics, which should have gone to the court, and if they had gone to the court and if they have the compensation on behalf of Videocon company, let's say, then yes, we could have said that the court will award a compensation, because only the parties to the contract can approach the court for its enforcement. Videocon here is not a party to the contract, and therefore they have no right, and there is no they have no occasion to approach the court for a relief in whatsoever manner, and therefore, as far as the choices are concerned, I would say that B is the better choice, which says that since Videocon is not privy to the contract, Doorchitra is not liable to compensate Videocon for this reason. Okay, so any questions? So this is a bit tricky and not that straightforward. So yes, you are saying that agreement clearly provides. Yes, it definitely provides. But the question is whether Videocon can approach the court. So I would put it that B should be the correct answer out of the 4 choices which are given to us. Moving on to the next. The principle is nobody shall unlawfully interfere with a person's use or enjoyment of land or some right over it or in connection with it. So there should be no interference with the person's use or enjoyment of his land or the rights over the land. Right means right of passing, right of cultivating, right of using, etc. The use or enjoyment envisaged herein should be normal and reasonable, taking into account surrounding situation. So now this is not absolute. This right of use, this right of enjoyment is not absolute, but it should be reasonable, and reasonableness is to be considered taking into account surrounding situation. Now the facts are Jeevan and Pawan were neighbors in a residential society. Pawan started typing classes in a part of his house, and his typing sound disturbed Jeevan, who could not put up with any kind of continuous noise. He filed a suit against Pawan. So what do we say? I think it's fairly simple. It's a residential society. So when the principle says that reasonableness is to be considered taking into account surrounding situation, as far as this particular society is concerned, the surrounding situation implies that it's a residential society and therefore it should be used for residential purposes only. So if Pawan has started using it for commercial purposes and then he is using the property in such a way that it is disturbing the neighbors, then obviously we can say that there is an interference on the part of Pawan in the lawful use or enjoyment by Jeevan, and therefore we will say Pawan is liable. Now Pawan is liable for which of these 2 reasons between A and B? B is not correct because it says that as a neighbor he should have realized Jeevan's delicate nature. So the principle does not speak about such peculiar circumstances of one particular neighbor, G1 may be delicate, may not be delicate. That is not really relevant. What is relevant is whether Pawan is using the property in a normal and reasonable way. And in this case, since he is using it for commercial purposes, therefore it is not the normal and reasonable usage of the property, property being a residential property. The correct answer is A. Pawan is liable because he should not have started typing classes at all in this house, because it's a residential society and it should have been used only for residential purposes. Okay, next one. Principle is any direct physical interference with the goods in somebody's possession without lawful justification is called trespass to goods. So direct physical interference with the goods in somebody's possession. That is what is required. Direct physical interference with the goods in somebody's possession. Facts of the case are: A purchased a car from a person who had no title to it. A sent the car for repair to garage. X, believing wrongly that the car was his, removed it from the garage. This is again a very interesting question. I'll give you a minute to ponder over, and then we'll discuss. Well, there are only two choices here. X can be held responsible, X cannot be held responsible. And now let's see again what is trespass to goods. As per definition, as per the principle, any direct physical interference with the goods in somebody's possession without lawful justification is called trespass to goods. Now you will notice here that what is required for this principle to apply is that goods must be in somebody's possession. That possession may be with title, without title. It doesn't speak of the title, it doesn't speak of ownership. It only says that goods are in somebody's possession. So in this case, the car was in A's possession. He purchased it from somebody who had no title to it. Regardless of that, car is or was in A's possession and he sent the car to the garage, which means the car is still in A's possession. Garage is holding it only on behalf of A. So legally speaking, the car while in garage is still in A's possession. And if it is taken from the garage by X without a lawful justification, as the principle uses the phrase lawful justification, if X has removed the car from the possession of A, the car while in garage is still in possession of A. X has removed it from possession of A without there being any lawful justification, and therefore clearly X can be held responsible for trespass to goods. So the correct answer here will be A. Is that okay? All right. Next, the master principal is liable for all acts done by his duly appointed servant agent for all acts done by him lawfully in the course of his employment. This is the same principle as we saw earlier. In the case of the state, the same principle is applicable here also. So, in the course of employment, whatever is done by the agent, the master is, or the principal is responsible. The facts are A, B, C and D carried on a business in partnership. While making a deal with another company, B bribed the clerk there. Is the partnership firm vicariously liable? Now firstly, let's understand that when A, B, C and D are partners in a business, all partners as per the partnership. So A is an agent of B, C and D. Similarly, B is also an agent of A, C and D, etc. And in this case, B has done something wrong. But let us first of all understand that being a partner, B is an agent of the other three partners. That is, B is an agent of A, C and D. That is one thing. And now B is entering into a deal with another company. And while entering the deal, he has bribed the clerk there. Now this act of B might have been authorized by the other partners, might not have been authorized by the other partners. But still, can we say that this act was done during the course of his employment, or during, or whether this act was done while doing the business of the partnership? If the answer is yes, then yes, that principle will apply, otherwise not. So just consider it for half a minute. Alright, let's now consider the choices. First choice is no, as bribing is not in the course of employment of the partners. Now this act of bribing is done in the course of employment or not? I think it is definitely done in the course of employment, because the partner is in fact striking a deal on behalf of the firm, and therefore whatever he is doing it on behalf of the firm and during the course of business activities of the firm. So it is definitely in the course of employment. Going to choice B, it says yes, as partners are agents of the firm. Yes, partners are agents of the firm, as I told you earlier also. C, yes, as B can be said to implied authority for the same. I doubt whether he has an implied authority of bribing the clerk. So that doubtful, that's doubtful. D says no, as this act was not authorized by the others. Again, we do not know whether it was authorized by the others or not. But I think one thing which is missing in all of these choices is the word which has been emphasized in the principle, which says that I'll read the principle again. The master principal is liable for all acts done by his duly appointed servant agent, for all acts done by him. For all acts done by him lawfully in the course of his employment. So there are three separate divisions of this principle. Firstly, all acts done by the person. So this is definitely an act done by an agent, an act done by a partner, and it should be lawfully done. And thirdly, it should be done in the course of his employment. So in my view, the act is done by the partner as an agent. It is done in the course of his employment, but it is not done lawfully, because the law does not approve of any bribe being given to anybody. So it is not a lawful act, and therefore, as per the principle, the other partner should not be held liable. So the answer should be no. Now we have no in option A, we have no in option D. Which of these two we should tick? Firstly, in the first choice it says no, as bribing is not in the course of employment of the partners, and second, last choice is that no, because this act was not authorized by the others. So since we have to tick one of them, I would have preferred that lawfully should have been used in one of the options, since it's not there, and since we have to tick one of the options, I think the nearest correct answer should be A, no, as bribing is not in the course of employment of the partners, and therefore the other partners are not liable for this act of the this act of partner B. All right, so students, we'll stop here, and I'll now hand over to Vivek sir. He'll be dealing with the rest of the questions. Thank you.
Hi folks, thank you sir. That was I think a very interesting session. I think some good tough questions we dealt with and lots of confusions I hope have been cleared up. The stuff guys, if you are getting panicky and thinking that these questions are maybe things that you'll have to leave in the exam, don't worry. These are tough questions. They are certainly not easy questions. But in the exam, you'll get a mix of all kinds of questions. You'll get mix of easy, medium and tough. And leaving a tough question is not a bad thing. It's actually a good decision because you have 175 questions and you have less time to do it in. So it's totally fine. These questions we are discussing them in the doubt sessions so that you have a basis, so that you have an understanding, and then you can attack easier questions also later. So the folks, now the time is actually 12:40, beyond 12:40, and I want to be wary of everybody's time. We have more questions to go through, but I think now we're out of time for this doubt session. So what I'll do is let's draw the line here. Let's close this doubt session here, and we'll either deal with these questions, the remaining questions in the next session, or we'll do one-off videos for them and add them to your account. No worries. The remaining doubts are also quite interesting. I think Narayani, a couple of doubts that you had asked are still pending, and a couple of other folks' doubts also are still remaining. But we'll go through them either in the next doubt session or midweek. We'll do something else for that. There were some good questions on logical reasoning also that I wanted to go through, but again, like we're out of time, so maybe we'll do it sometime soon. Okay, folks, I think we're about to wrap up now. Any other doubts, any other last minute thoughts that you wanted to ask or share? Okay, looks like we're all good. You know my email ID. If you have anything else, either write to me or write to the team, and one of us will get back to you very soon. All right. No, yeah, Bhavan. So that's the mystery right now. Nobody knows as yet, but I expect in this coming week that DU will be clear about the date of the exam. We sent out a mail, I think last week, which was talking about the Maharashtra CET notification and the confusion that is created because the date is the same as Punjab and potentially DU also. So the summary of that long mail was, I think, just this, that if you don't have state quota or state domicile in Maharashtra, there are a number of ways to qualify. But if you don't qualify any of those ways, then essentially the number of seats that are available to a student who is basically from the rest of India quota are very, very low. So your chances are, just speaking from a frank probability perspective, chances of success in Maharashtra CET are lower. And the recommendation was that if you don't have a state quota in Maharashtra, then that day could be better allocated to DU or PU. Now, if it turns out that you are not at all keen on writing Punjab University and Delhi University's exam is not on 19th, then you have 19th free. So then, of course, you should write Maharashtra CET, right? Much better to write an exam and get a rank rather than not writing it. So that advice was really just for if you have a clash, if DU decides to hold its exam also on 19th, or if PU is on 19th and you are planning to write PU, then what to do. As far as DU's date, we'll come to know in probably the coming week. Vikram, yeah, the logical questions that are pending, you're right, they are pending. You had asked some doubts. They're actually from the material itself, folks. I just wanted to clarify for the rest of you. Vikram had asked some doubts, but they are from the material. So if you've been able to solve them, that's fine. They're not new questions. So Vikram, either I'll send you the solution separately, or I'll do a video and I'll upload it to the accounts for everybody so that you can see. Yeah, Mr. Sopti, the GK section is a mystery. So it's a mystery to us also. But what we have done personally to make the material for you guys, for the material that is given in the course or sent by post, is that we have looked at the last 8 years of DU papers, and we've basically seen the trends, or we've seen what sections they tend to ask their GK questions from. And from there, that's where we've generated what we give you as a common minimum set. The set that, or whatever GK content that you have, by no means is that going to be 100% of what is asked in the paper. What we hope is that it will cover 70 to 80% of what is asked in the paper, and the remaining 20% is really luck and chance. So the more you read, the wider you read, the better. But even then, it's impossible almost for any student to have 100% preparation for the GK section, simply because there's no telling where you will pull their questions from this year. But yeah, the more you read, you're referring to the add-on. Not very clear. What add-on are you talking about? Are you asking for this year, for 2016, what is being increased? Oh yes, you're asking what has been added in our material. We've of course the biggest change is in the current affairs, and we've tightened up a lot of sections. So you won't notice it honestly because you have been studying the material after updation. But if you had seen our material for last year's batch versus this year's batch, then you'd see lots of changes. You already have the updated material. We've done lots of improvements in especially in the UN bodies section, books and authors, legal maxims was another. In the Indian geography section, we've added more content, better diagrams, stuff like that. But you already have the updated version, so for you, you won't notice much difference. Yes, it is, Narayani. That's coming. That sentence improvement chapter is still TBD. It's pending. It's going to come soon. All right, folks. Any other doubts? Great. Most welcome. And it's always great interacting with you folks. And we'll talk to you soon. Best of luck and keep studying. Take care.